Rob is a member of the Repossessions Working Group that is currently looking at the issues faced by unauthorised tenants. Rob, over to you. Thank you very much.
Thanks for that kind introduction, Graham. I was half expecting to be announced today with shouts from the audience floor of "He's behind you," followed by boos and jeers, being the sole representative of the legal and lending fraternity today. Anyway, feel free to boo and jeer at any point in what I have to say this afternoon. My aim today is to keep things relatively simple. I don't want to go into great depths about technical aspects of the legislation. I don't propose to represent the views of the lending establishments. I don't propose to be speaking on behalf of Aberdeen Considine. Everything I say today comes with a health warning that it's probably pure speculation, conjecture, and at very best it's an educated guess. When the new landscape hits us on the 30th of September, very little will actually change for lenders. Most proactive lenders already apply the English pre-action protocol to Scottish cases. The PAR largely mirrors the English PAP, lots of PARs and PAPs. What does change in my view though is the balance of power very much moves from, I think, the lender to the borrower, and hence why I've said from shouldn't to should. At present it's the borrower who has to go into court and convince the sheriff why the lender shouldn't be able to take the property. I think the balance will very much shift, and it will be the lenders and therefore the solicitors acting for the lenders that are required to go into court and convince the sheriff why they should be entitled to take the property into possession. What I thought I'd try and do is give you a flavour of how I foresee a new application being made in the new court process. I've called it the new landscape, and again comes with the caveat that I'm not sure if this is exactly what will happen, but educated guess. As I've said, very little changes for the lenders. Most lenders, when they've looked at the PAR, it's pretty much in line with the PAP, so they're quite content. They're certainly the good lenders, primarily the first charge lenders, they're happy that they're compliant already. So they'll go legal. What we would suggest happens, and already some of these lenders do this already, they apply the English PAP to Scottish cases. They'll send us a PAR pack. That will demonstrate that they've complied with pre-action requirements and indeed that they've been reasonable, which is the important test in the new legislation. We'll then check the PAR. Again, we are the solicitor who's going to appear for the lender on their behalf in the courts. So we want to be certain what we are saying to the sheriff is accurate. We'll continue to serve the Section 11 notice as we do at present for lenders. What will actually change is that for many lenders we used to write out and do a 7-day letter. What we changed about a couple of years ago was that we went straight to court action, no kind of interim measures. We're going to reintroduce this because one of the technical requirements will be that we need to provide information to each borrower about the contact details for the local authority homelessness department. So we've offered to do that on behalf of lenders because again they're applying a UK set of conditions, and their case management systems are driven by volume. So we're going to take the burden off them at a localised level. We'll then proceed to draft the summary application. We'll complete the forms that Eric and others have touched on today. I think there will be a checklist certainly saying, again, tick boxes, have you been compliant? Yes, and we're giving that undertaking on behalf of the lender. We'll send the summary application off to the court to get warranted. Summary applications, unlike your ordinary cause rules at present, require the obligatory calling. We'll get the hearing date for that first hearing. I've said here, I think, being optimistic, we might get a hearing date 2 to 4 months after we get the writ warranted. That is, I think, optimistic. I had a case last week, a summary application for recovery of heritable property, an eviction action. We sent the writ to the court at the end of May. We got it back warranted in June, and we've got a hearing date for the 13th of September. So to put that in context, you're looking, in my view, at probably a 900% increase in the amount of cases that are calling in court, factoring in continuations, multiple continuations, lay representation. I would speculate that there might be some delays, and indeed when the PAP was introduced in England, there was tales of 6 to 9 months before the first hearing date. So bear in mind there may be a lag. I have no doubt the situation will improve, but I think to start with there could be significant delays. So we're going to go along to that first hearing, whether it be 2, 4, 6, 9 months later, and the sheriff has immediate discretion to actually kick the case out at that point. If he deems that the lender hasn't been PAR compliant, or he deems that they've acted unreasonably, they don't pass the reasonable test, that case will be put out, the expenses will be awarded against the lender, and it will be the end of the action. What could possibly happen, and again speculation, is a continuation if you have the borrower or somebody representing the borrower in court alluding to something that the parties can't agree on. There may be a continuation for further investigations, for more information, with a further hearing, and after that continuation it may still result in a dismissal, again if the borrower is able to prove that the lender hasn't been compliant, or equally it could result in a decree. What I think will be the more common scenario, probably in around 90% of cases, where a borrower does attend, or somebody representing the borrower attends at the court, there'll be answers ordained to be lodged, perhaps with a period of adjustment and a further hearing date called. What's not been touched upon today, and what might not be immediately evident, is that the Mortgage Rights Scotland Act, which some of you may be familiar with already, will be largely repealed, so your mortgage rights minutes are no longer available. This will be the formal process for convincing the court that the borrower should be allowed more time to stay in the property, or indeed evidencing to the court that the lender hasn't been PAR compliant. And as with the mortgage rights procedure at present, ultimately if negotiations are unsuccessful, and again most lenders and solicitors acting for lenders while the court process is up and running will continue to have extrajudicial conversations about the process and try and enter into some form of arrangement. If that can't be achieved, then we'll end up in an evidential hearing, evidence being led and a decision being made. Again, decision, dismissal, decree, and not forgetting that if the borrower doesn't turn up at the first hearing, or indeed if answers are ordained to be lodged and the borrower doesn't actually follow through with the answers process, you're going to end up with a decree being granted. One of the things I actually asked Eric this morning, and I couldn't get my head around what would happen, is if the evidence is led and the sheriff is significantly convinced that the borrower should be allowed more time. I thought, is it either going to be a decree or no decree scenario, because we've moved the burden to pre-litigation. What Eric suggested, and I think this indeed will be the case, is that we'll have a decree granted, but it'll be suspended for extract. Now, in England they have suspended possession orders, which is exactly akin to the same procedure. So I could see a decree being granted at any stage in this process, but ultimately the extract, which is the key document we need to carry out an ejection, wouldn't be passed out to us to perhaps 3-6 months later. So I think there is still an optional get out of not an absolute decree at the end of the process. The whole process will end as normal with an ejection. At present, we recommend to all our lender clients that we get a summary warrant, that we don't get a summary warrant for ejection. It's a very technical, a slight technical difference, but without a summary warrant to eject, we have to serve a charge to eject. The charge to eject typically is around 14 days prior to the actual ejection. It's served by sheriff officers, and what we find is that by far the greatest percentage of rehabilitation occurs in that 14-day period. With the change in legislation, what we're recommending to lender clients is that they remove the requirement to do a charge to eject, and if they get a decree, go straight to the ejection at the earliest possible opportunity. So it may change our process slightly. Two things not to forget about that have been alluded to today. The kind of top red line there is probably as close to what I would imagine will be a standard application as possible. Throw into the mix recall and an entitled resident application. A couple of things to remember about recall. The persons entitled to recall will actually be the lender, the borrower and any entitled residents, and that recall is competent any time up to decrees granted, until decrees enforced. And entitled residents are the same sort of people that had rights under the Mortgage Rights Scotland Act. Again, they can get involved in the court process at various points, and it will send it right back to the hearing at the very start. A couple of things to note, again, half warning on these, it's me having a go at guessing what will happen. Recall, at the moment it's arguable whether a creditor in action is entitled to repone in the ordinary cause process. Eric will maybe keep me right, some courts allow it, some don't, but there's a clear facility for a creditor now where a borrower or somebody representing the borrower says, look, a decree will have a financial bearing on the borrower in years to come, can you get the decree recalled, then we, acting for the creditor, can now actually go and do this. As I said, it prevents enforcement. What's interesting is that recall will be required to be served on other parties to the action, so again, you'll be required to do it on the lender and if there's other defenders in the action or other entitled parties. And again, pure speculation, but if a person seeking to recall does not attend the first hearing, so the normal scenario would be that a hearing would be put in place. The borrower the person seeking the recall would be expected to attend to that hearing. If they don't attend, it won't be an automatic dismissal. There'll still be a further peremptory diet. So again, being a cynic, if I was representing borrowers, I think there's a tactical game to be played there, certainly to buy a bit of time if it helps the borrower's position. What's still unclear is entitled persons or should be entitled residents. If we find out that the borrower is living with somebody, perhaps they're not on the mortgage account, maybe it's a partner, a cohabitee. We know from our case history notes that Jeannie has got a partner, John. He's the sensible one. He's been the guy that we've been talking to rehabilitate the account. I understand that it may be a requirement that we name that person in the writ and have a copy of the writ served on them. Now, if we don't know their name and our lenders don't know their name, is that not penalising a forbearant lender? So it's something that I think will hopefully be dropped when the rules do come in. And again, what's still unclear to me is if entitled persons come into the process, how they interact with the standard process. You could have a number of different people on a number of different timelines, and how do they all come together and how do they interact? Voluntary abandoned, very quickly. Voluntaries, at present, the best course of action for a voluntary in Scotland is to get a calling up notice signed, and very quickly thereafter, a period of 1 month and 1 day, we can take the property into possession. We're now going to have written certification from all entitled residents and the borrower, who will be the principal defender in the action. We'll still need the calling up notice signed, albeit we can get it on a short period of notice. What I would suggest here is that some lenders might not use it, because I think it will be quite burdensome to actually get a hold of entitled residents to sign this certificate, and it may mean that they just choose to go down the court action route. And abandons, at the moment the extractor at the court of session can actually step into the shoes of the borrower and sign on their behalf. If we're actually moving into the new arena, I don't see abandons being possible anymore. It'll just be a standard court action. And again, what's very interesting to me is that at present, where there's an abandoned property and we can't find the borrowers, the sheriffs are increasingly not allowing us to serve actions on walls of court. What that means is that we've got to go and advertise in the local newspaper. To stick an advert in the Herald is 500 quid, so you're immediately, in an abandoned scenario, adding £500 onto the mortgage arrears. What are we going to do differently? We might be instructed earlier. Lenders might ask us to take action earlier on in their pre-litigation procedures. We'll be doing the PAR compliance, and we'll be sending the information, as I said earlier. We'll be appealing personally at as many hearings as possible. At the moment we tend to use local agents. It's more cost effective for the lenders and for the borrowers, but my guys are actually going to get out on the road and get into the courts to make sure the decisions are right. Instructed to be more aggressive, that's not a statement at all, but I would ask the question, if you were a lender and you thought it was going to be 12 months before you got a decree, would you change the standing instructions to the solicitors? Because multiple continuations, multiple recalls, increased interaction with borrowers, lay representatives, I'm not sure. It may happen, it may not. And you wouldn't expect a lawyer to turn up and not talk about fees, but already we're looking at probably a doubling or a tripling of fees. We had a meeting with one of our major clients who recognises that we're looking at least double the legal expenses. At the moment, it's a paper-based process. We don't turn up in court. We're looking at least 2 hearings in court, 2 lots of preparation, answers, lots more preparation and appearance time. I'm conscious I'm running way behind, so I'll just stick some bullet points up here. Strengths and weaknesses, maybe some questions as opposed to actually statements, but things to make you start thinking. It is a bit of a chances charter. It does afford the luxury to the guys who are not genuine of using the process that's intended to be for those who are deserving of it. Entitled persons I've talked about, lenders potentially forced to litigate and voluntary and abandoned. Delays, very simple maths. If somebody's delaying possession and they're not going to get a decree against them and an ejection served for an additional 12 months, That's 12 months of arrears, interests, ultimately shortfall, and long term, does it create more debt issues, more sort of inhibitions, harassments, bankruptcies? Are we delaying the problem? Possession, as you probably well know, is actually good for some borrowers, but the whole process becomes more clunky and longer. One technical problem for us as a representative of the lender is that the Rules Council, the Sheriff Court Rules Council, aren't actually going to issue any court procedures until August. This new legislation is going live in September. It gives us very little time to prepare systems and train and educate. Increased fees, I've talked about. A question, do solicitors represent borrowers' interests better? Is a borrower going to do more harm than good turning up and trying to represent themselves? Lack of funding for the Scottish Court Service. They only got £300,000 to deal with this whole change in the process, and that's physical buildings, resourcing, training. Would the money have been? Is more money needed for the free money advice sector? Burdensome framework and a positive economic climate. When we go back to the good old days where we've paid off our massive deficit, is this going to be a disincentive to lenders to lend in Scotland because it's so difficult to recover? And for what's worth, my own viewpoint, I would have probably tweaked the Mortgage Rights Scotland Act, increased awareness. I would have funded the mortgage to rent and mortgage to shared equity schemes more, increased awareness of them. I do think there's an element of political gesturing. The government's done the easy thing and changed the court process. It's a lot more difficult to throw tens of millions of pounds at keeping people in their homes and renting them back to them or sharing equity. I think I'm out of time. Strengths, as Gavin alluded to, the forms are a bloody nightmare. I mean, lawyers struggle to read them, but they are less of a nightmare. Rehabilitation will improve. Less scrupulous lenders who weren't perhaps compliant will be compliant. Good lay representatives absolutely will improve access to advice and improve representation. And there's more. There are protections in the pipeline. Gavin's touched on tenants, so I won't go over the same ground again. What's interesting is that the Bankruptcy and Diligence Scotland Act Part 15 actually has on the statute, it's not actually live law, but an obligatory 14 days of charge where there's going to be an ejection. So the reality is that that's still potentially going to come in, and it may force me to go back to the position we adopted previously, where we do serve a charge on the borrower and then come back again to eject them, given time for rehabilitation. Conclusions: well-intentioned, politically driven, less scrupulous lenders, more focus on keeping people in their homes. Inevitably mean delays, not better for all borrowers, and will hopefully increase the chances of borrowers getting involved in the court process and obtaining representation. Thanks for your time.
Thank you very much. Just stay there a minute.
Take a deep breath now.
Take a deep breath.